Attorney Kimberly Motley appearing in person with Linda and Jay Anderson, as well as Starkisa Della Rosa. Good morning.
Good morning. All right, before I deliver the decision, I have a couple of preliminary remarks that I'd like to make. We are on live stream this morning. I want to begin by commending counsel for her presentation of the evidence in this case. I want to thank the Milwaukee County Sheriff's Department for their excellent service throughout these hearings, in addition to today. I also want to thank my staff, both of whom are seated in front of me, who never let me down. This decision has not been taken lightly, nor was it predetermined. It is the result of a careful and extensive review of the evidence in this case. This matter comes before the court as a petition to appoint a special prosecutor to prosecute Wauwatosa Police Officer Joseph Mensah for criminal conduct in connection with the fatal shooting of Jay Anderson Jr., which occurred on June 23rd of 2016. This petition has been filed under Section 96802, Sub 3. That statute reads as follows. If a district attorney refuses or is unavailable to issue a complaint, a circuit judge may permit the filing of a complaint if the judge finds there is probable cause to believe that the person to be charged has committed an offense after conducting a hearing. If the district attorney has refused to issue a complaint, he or she shall be informed of the hearing and may attend. The hearing shall be ex parte without the right of cross-examination. Milwaukee County District Attorney's Office, in a letter dated December 5th, 2016, from Chief Deputy District Attorney Kent Lovern to Wauwatosa Police Chief Barry Weber, former police chief, indicated that it had concluded that Officer Mensah's shooting of Mr. Anderson was a privileged use of force in self-defense under Wisconsin law, and that they had concluded their review of the matter. Counsel has also indicated that petitioner has requested that the District Attorney's Office reopen their review of the Jay Anderson Jr. shooting subsequent to the fatal shooting of Alvin Cole by Officer Mensah in a letter dated June 16th of 2020. According to counsel for the petitioner, a written response to that request was never received. The court finds that the Milwaukee County District Attorney's Office has refused to issue criminal charges in the fatal shooting of Jay Anderson Jr. The court also finds that the Milwaukee County District Attorney's Office has been informed of these proceedings. As noted in the petition, Section 96802 Sub 3 provides both a forum and a procedure for a citizen to ask a court to review a district attorney's decision not to issue criminal charges where that citizen believes one or more crimes have occurred. Under the statute, the petition is heard ex parte, meaning the only participants are the petitioner and the court. No other parties have a right to participate. Although the statute affords the district attorney the right to attend, it does not provide a right to cross-examination or to otherwise be heard either in person or in writing. The court has had the benefit of reviewing the December 6, 2016 letter previously referenced, as it has been admitted into evidence in this hearing. Section 96802 Sub 3 has been repeatedly upheld by Wisconsin courts. The statute was created as a means to scrutinize a district attorney's decision not to charge criminal conduct in a given situation, a decision that is often made out of the public eye. That is the rationale for conducting hearings under this statute in public, absent a compelling reason to do so. The statute does not provide any right to rebuttal or to present evidence contrary to the petitioner. The hearings in this case have been conducted in open court as well as live streamed. court has relied upon the seminal case of State ex rel. Kalel versus Circuit Court for Dane County, as well as State versus unnamed defendant, and State ex rel. Newspapers, Inc. versus Circuit Court for Milwaukee County, in understanding the statute. It is important to note that this court's review is limited to assessing only whether probable cause exists to charge Officer Mensah with a crime. It is not within the scope of this court's function to consider or offer opinions about what may or may not be provable by evidence beyond a reasonable doubt, the high standard by which any criminal charge must be proven. Probable cause refers only to the level of proof required before actions in a criminal case may occur. Wisconsin courts follow a totality of the circumstances approach to evaluating probable cause. Historically, probable cause to arrest refers to that quantum of evidence which would lead a reasonable officer to believe that a defendant probably committed a crime. It is not necessary that the evidence giving rise to such probable cause be sufficient to prove guilt beyond a reasonable doubt, or even that guilt is more likely than not. It is only necessary that the information lead a reasonable officer to believe that guilt is more than a possibility. The evidence must show that there is more than a possibility or suspicion that a defendant committed an offense. Once charges are issued in a felony manner, probable cause must be established by testimony and or other evidence to show that a felony was probably committed within the jurisdiction and probably committed by the person charged in the offense, a higher level of probable cause than that necessary at the time of arrest or the time a person is charged. The court will provide a brief timeline of known facts that led up to the fatal shooting of Jay Anderson, Jr. on June 23, 2016. At 1:37 a.m., Mr. Anderson was observed driving into Madison Park and parking his vehicle in the Madison Park parking lot. His vehicle never moved, and he is not observed having contact with anyone else until the time of his encounter with Officer Mensah. At 3:01 a.m., a marked Wisconsin SUV, later identified as the vehicle driven by Officer Mensah, can be observed entering Madison Park. At 3:06 a.m. and 45 seconds, a series of small flashes consistent with muzzle flashes from a gun being fired can be observed. At 3:08 a.m., other Wauwatosa police squads can be observed arriving at Madison Park. The observations that have been referenced here were all captured by video recovered from the Madison Elementary School, which is adjacent to Madison Park. Exhibit 85 is an audio recording of Officer Mensah's communication with the dispatch radio operator in the minutes that led up to the shooting. As the recording begins, Officer Mensah is calling in a report of an occupied vehicle in Madison Park. Approximately 54 seconds into the recording, Officer Mensah called in the license plate for the vehicle occupied by Mr. Anderson. At 1 minute and 24 seconds into the recording, Officer Mensah was advised that the vehicle was registered to Elena De La Rosa, the mother of Mr. Anderson's fiancée. At 3 minutes and 35 seconds, we hear Officer Mensah say, "Step it up, he has a gun." At 3 minutes and 44 seconds, we hear the dispatcher say, "All squads respond to Madison Park." At 4 minutes and 41 seconds, we hear Officer Mensah say, "Shots fired, shots fired." Immediately thereafter, the dispatcher can be heard directing all squads to respond to Madison Park. Approximately 5.5 minutes after Officer Mensah entered the park, Mr. Anderson was shot. Exhibit 85 also includes the squad video from Officer Mensah's vehicle. Officer Mensah did not activate his camera until after the shooting. By automatic operation, it captures video but not audio, beginning approximately 30 seconds before it is activated. So it has approximately 25 seconds of recording prior to the shooting. It shows Officer Mensah in a shooting position with his arms extended towards Mr. Anderson, as well as the movements inside the vehicle by Mr. Anderson. It also shows the shooting of the deceased. Testimony commenced in this hearing on February 25th, 2021, and concluded on May 4th, 2021, followed by closing arguments on May 19th of 2021. Witnesses who were called to testify included Mr. Hakeem Fudge, a close friend of Mr. Anderson, Mr. J. Anderson Sr., father of Mr. Anderson, Starkeisha de la Rosa, fiancée and mother of Mr. Anderson's child, Dr. Wislawa Tolomak, Deputy Chief Medical Examiner for Milwaukee County, Pamela Holmes, retired Milwaukee Department Sergeant, Lieutenant Joseph Roy, Wauwatosa Police Department, Barry Weber, former Wauwatosa Police Chief, James Trainum, retired detective from the Metropolitan Police Department in Washington, D.C., Ricky Burhams, retired detective, Milwaukee Police Department, and William Harmoning, retired Chief Special Agent and Adjunct College Professor at the Illinois Security Department and Washington University, respectively. Former law enforcement officers Burhams, Trainum, Holmes, and Harmoning have a combined total of 122 years of law enforcement experience. Ricky Burhams has 32 years of experience with the Milwaukee Police Department, 10 years as a homicide detective. He testified that he has been involved in about 1,000 homicide investigations, thousands of shooting investigations, and 15 to 20 officer-involved shootings. James Trainum has 27 years of law enforcement experience with the Metropolitan Police Department in Washington, D.C., including 17 years as a homicide detective. William Harmoning has 37 years of experience in law enforcement, including 18 years as Chief Special Agent for the Illinois Securities Department. He is certified as a police instructor through the Illinois Law Enforcement Training and Standards Board, in addition to having 20 years of college teaching experience in the areas of forensic psychology, use of force, and criminology. Pamela Holmes has 26 years of experience with the Milwaukee Police Department, including 18 years as a sergeant supervising patrol officers. All four of the witnesses referenced have testified that they have not been compensated in any way for their testimony. The court is aware of two cases in which Mr. Trainum was not permitted to offer expert testimony. In both of those cases, he was brought in to testify on the issue of false confessions, a phenomenon not at issue in this case. The court is also aware of two cases that Mr. Harmoning was not allowed to testify as an expert. The court has reviewed those cases and does not find that they form the basis to disqualify him from offering testimony in this matter. The court will now address the evidence adduced over the course of these hearings. The evidence has shown that on June 23rd, 2016, Officer Mensah drove into the Madison Park parking lot at 3:01 a.m. and positioned his vehicle approximately 2 car lengths from the Anderson vehicle, facing the Anderson vehicle, with its high beam takedown lights on and its emergency flashing red and blue lights off. Failure to activate the emergency lights is significant because doing so would have automatically activated the dash camera of Officer Mensah's SUV, squad car. The first question raised was whether the encounter between Officer Mensah and Mr. Anderson should be considered a traffic stop. Retired Sergeant Holmes testified, absolutely, yes, in response to a question asking if she would classify this encounter as a traffic stop. She went on to testify that if they are inside of a car, it is considered to be a traffic stop. Retired Detectives Burns and Trainum also testified to the encounter being a traffic stop. Retired Chief Special Agent Harmoning testified to the contents of Wauwatosa Police Department entitled Vehicle Contacts Training 2020, which was Exhibit 34. Commenting on the document, Mr. Harmoning testified, "This is training on how to properly conduct a traffic stop. Officers are trained to stop a car length behind and offset on the driver's side." Mr. Burns and Ms. Holmes agreed. Officer Mensah should have been parked behind the Anderson vehicle for officer safety reasons. Mr. Burns testified that there was no productive reason for Officer Mensah to position his squad the way that he did. Acknowledging that Officer Mensah was behind the Anderson vehicle at one point in order to see the rear license plate, he said the following: "So we know that at one point Officer Mensah was in the proper position to make a traffic stop, and he was at the rear of Jay Anderson's car, where he should have been and where he should have stayed." Mr. Trainum testified that it is important to activate your emergency lights so that the occupant of the other vehicle knows that you are the police. Mr. Trainum testified to the contents of Wauwatosa Police Department operating procedure for in-squad digital video system, Exhibit 44. The squad camera system begins recording automatically upon the activation of the emergency lights. The directive requires the recording of all traffic stops under the procedure section A, sub 1, sub C. Mr. Trainum also testified that under section sub C, sub 1, Officer Mensah was required to record all traffic stops with his wireless microphone. Officer Mensah did not activate his squad camera or wireless microphone until after the shooting. Exhibit 58 is a report detailing in part a conversation between Wauwatosa Police Department Lieutenant Gary Gabrish and Officer Mensah approximately 9 minutes after the shooting. Lieutenant Gabrish asked Officer Mensah, "Did you have this recorded by any chance?" Officer Mensah replied, "I tried to hit the button a couple of times." There was no follow-up investigation establishing that there were any defects in Officer Mensah's recording equipment, nor did he mention that his recording equipment had malfunctioned when he was interviewed by Milwaukee Police Detective Luke O'Day the day after the shooting. Officer Mensah appeared on the Dan O'Donnell radio show on July 28th of 2020. During that interview, he denied violating any department policy by not recording his interactions with Mr. Anderson until after the shooting, and said the following: "There's reasons and circumstances when that gets turned on. It's turned on because I turned it on. You can't accidentally bump that camera. It's in a leather case. You have to physically turn that button on. I turned it on. I turned it on because I knew that people would want to believe me. But I needed them to. I needed to have that evidence to support what I saw. So I turned that on fully knowing that once I hit that button, it would go back, 20, 30 seconds, and it would capture that. I did that." Additionally, although Officer Mensah made a statement that he drove through the park at 12:30 and did activate his emergency lights to encourage people to leave the park, this was never verified, as no request was made to obtain the video from the school for that time, and there is no evidence of squad camera footage from that time that would have been automatically generated had he activated his emergency lights. The court has also heard testimony that Officer Mensah failed to activate his emergency lights or recording equipment at the time Antonio Gonzalez was shot in 2015. Officer Mensah leaves one with the impression that in the absence of a self-serving purpose, he does not see any other reason to record his actions as a police officer. The concept of transparency as to his interactions with the public does not appear to be a concept he has given any consideration to. Based on the timeline, the evidence shows that there were just over 2 minutes that transpired between the time dispatch provided information regarding the Anderson vehicle to Officer Mensah and the time he told dispatch to step it up because he has a gun. About 1 minute and 6 seconds later, he shot Mr. Anderson. Approximately 20 minutes before the shooting is when the recording begins to capture video. Officer Mensah made statements to Lieutenant Gabrish shortly after the shooting that were recorded. He stated, "Just a regular occupied auto. I went around to the passenger seat. Knock and knock and knock. Nothing and nothing. Look down. Just doing my search, whatever, and I see a gun there. Pop it out. Hey, is that a gun? Step it up to dispatch." Then the whole time he kept doing this, kept doing this. He said the driver said, "I'm not reaching for it. It's nothing there, nothing there." Officer Mensah then says, "Stop, there's a gun right there." Lieutenant Gabrish then asks, "Is he up?" Officer Mensah replies, "Yeah, he's up, coherent and everything. Put his hands up. As soon as I woke him up, Wauwatosa police, saw the gun there. Get your hands up, get your hands up." Put his hands up. Kept saying, keep your hands up, and let's leave it at that. And he kept reaching for it, And the last thing was, he lunged forward again. Exhibit 59 is a summary of a 47-minute interview of Officer Mensah conducted the day after the shooting by Milwaukee Police Department Detective Luke O'Day. Unfortunately, the interview was not recorded on video. James Trainum testified that the International Association of Chiefs of Police has developed model policies in reference to police shootings, and it is recommended that these interviews be recorded. Officer Mensah told Detective O'Day that he approached the vehicle from the passenger side, observed the window was up, and scanned the vehicle with his flashlight for other occupants. He observed the driver lying back against the car seat, but felt he was faking being asleep as he appeared to be breathing fast. Officer Mensah tapped the window and identified himself but got no response. He continued to tap until the driver woke up, looked at him, appeared annoyed, shrugged his shoulders, closed his eyes, and leaned back in his seat. Officer Mensah said he called out to the driver that he had to talk to him, woke him up again, and that the driver lowered the passenger window. Officer Mensah said the driver told him he did not have a driver's license or ID on him, or anything that would identify his name. Officer Mensah stated he had been standing in arm's length from the passenger window and had seen the driver glance down towards the passenger seat several times. Officer Mensah stated he stepped forward, looked into the vehicle, and observed a semi-automatic handgun with an extended magazine, although he could not recall which way the barrel was pointing or what else was laying on the seat. The evidence showed that there was not an extended magazine for the weapon, but rather a clip with a handle on the end to assist with gripping the weapon. Officer Mensah said he was hazy with the exact chain of events moving forward. He believed he unholstered his weapon and ordered the driver to keep his hands where I can see them. He said the driver raised his hands to chest level, but suddenly reached towards the seat with his right hand while looking at the weapon, and that he then raised his gun, but the driver immediately raised his hands again when he yelled, "Hands up." Officer Mensah said that the driver made at least 4 separate movements with his right arm towards the passenger seat, but that each time he ordered him to stop, he returned both hands to the air. Officer Mensah stated that the last time the driver made a movement, instead of just his right arm moving toward the gun on the seat, his entire body lunged toward it. He said that when the driver did not comply with an order to keep his hands up, he discharged his weapon. Officer Mensah said he fired his weapon because he knew the firearm was on the passenger seat. He ordered and pleaded with the driver numerous times not to reach for the weapon, and he believed the driver was going to use the weapon against him. Ricky Burns and William Harmoning testified that at the time of Officer Mensah's initial contact, there was not probable cause that a crime had been committed by Mr. Anderson, only an ordinance violation for being in the park after closing. This continued to be the case after the gun was observed, as it was not concealed and the officer had no knowledge at that time that Mr. Anderson was legally intoxicated. James Trainum testified that the actions of Officer Mensah constituted officer-induced jeopardy, which he explained happens when an officer needlessly puts themselves in danger by committing tactical errors that were not forced upon them. He explained that Officer Mensah followed his training and parked. He explained that had Officer Mensah followed his training and parked behind Mr. Anderson initially, or moved to a position behind the vehicle after seeing the gun, he would have had a tactical advantage that would have required Mr. Anderson not only to take possession of the gun, but also to turn around first if he intended to harm the officer. He also explained that if his car had been behind Mr. Anderson, he would have had his car door and engine block to protect him had Mr. Anderson tried to harm him. Mr. Trainum also testified that it is important to compare the actions of Officer Mensah with the requirements of his department to determine if he conducted himself in a manner consistent with those policies in determining whether appropriate action would have prevented the fatal shooting in this case. He testified these decisions by Officer Mensah are relevant to charging because they impact what led to his decision to fire his weapon. Officer Mensah knew that backup was on the way before he engaged Mr. Anderson, but he chose not to wait for assistance. William Harmoning testified that he had yet to see a case where someone with the intent to harm a police officer and access to a gun did not attempt to do so immediately. After noting there was no reason to believe that Mr. Anderson was suicidal, he testified, "I have yet to see a case where an individual who did that was trying to fake out the officer by reaching multiple times." He continued, "The question he, Officer Mensah, can't answer is why did he let him reach 3 or 4 times before he decided to pull the trigger on the 5th time. Mr. Harmoning testified that Officer Mensah missed some critical opportunities to de-escalate the situation. All he had to do is ask him to step out of the car. He said himself he was up at the window when Mr. Anderson rolled the window down. All he had to do was reach down and pick up that gun and tell Mr. Anderson that for everyone's safety, I'm going to hold on to this until we're done. He testified that there's no difference between someone reaching for an ID or someone reaching for a gun. In this case, the evidence shows that although Officer Mensah claims that he was told by Mr. Anderson that he had no driver's license or identification, that there was in fact a Wisconsin identification card recovered at the scene. We have no corroboration for the identification conversation between the officer and driver because Officer Mensah failed to activate his recording equipment. Mr. Harmoning testified that Officer Mensah did not shoot Jay Anderson Jr. because he reached for a gun. He shot him because he lost sight of his hands. We do not know why Officer Mensah took a position where he would not be able to see the hands of someone who had already dropped their hands 4 times, knowing a weapon was present. We do know that Mr. Anderson was never observed to have touched or held the weapon during the incident. Vicki Burns testified that I would have been able to understand it if Mensah had said the first time Jay's hand came down, he thought he may be reaching for a gun. But to let this happen 4 or 5 times, so that should tell him that this kid is not reaching for a gun. He didn't do it the first time. He didn't do it the second time. He didn't do it the 3rd time. He didn't do it the 4th time. He's not reaching for a gun. The court heard testimony from Milwaukee County Chief Medical Examiner Wisława Tolomak. Her report is in evidence. She conducted the autopsy of Jay Anderson Jr. on June 23, 2016. She testified regarding 4 bullet wounds that she observed present on the deceased. Dr. Tolomak testified that the first gunshot had an entrance wound on his right ear and an exit wound on the left side of his head behind the left ear. The second wound she examined had an entrance wound on the right side of the head above and behind the left ear and an exit wound on the left side of the head above the left ear. Dr. Tolomak testified that these 2 wounds were considered through and through and right to left with no significant front to back or upward downward deviation. Wound number 3 had an entrance wound on the right cheek. She stated that the projectile perforated the right cheek and penetrated soft tissue on the right side of the neck. She recovered a 162 grain projectile from the soft tissue of the right side of the neck. The 4th wound she examined had an entry point of the right posterior shoulder. She recovered a 182 grain projectile from the muscles of the left side of the upper back. She indicated that the trajectory of the 4th wound was right to left, slightly front to back, slightly downward. Dr. Tolomak also performed a toxicology screen on Mr. Anderson, determining him to have a blood alcohol level of 0.114 grams per deciliter. She also testified his eye fluid for alcohol result was 0.15 grams per deciliter. The significance of this disparity, according to the doctor, is that it shows that his alcohol level was descending and that at one point it had been higher than 0.114. A screening test was also positive for cannabinoids, but she was unable to determine if he was under the influence of THC at the time of death. She did not note any other health problems during her examination. She ruled Mr. Anderson's death a homicide. Officer Mensah told Lieutenant Gabrish that Mr. Anderson had lunged forward and told Detective O'Day that he had lunged toward the gun with his whole body immediately before being shot. Former Detective Burns testified that he has been the lead detective in thousands of shootings and homicides over the course of his career. Regarding the allegation that Mr. Anderson was lunging towards a gun just before being shot, he offered the following testimony. First of all, his bullet wounds would have been in the front of his body, be it in the front of his head, or his upper chest, or even the top of his head. Secondly, a bullet strike is very high impact. It's an explosion, and there's a lot of power and energy. So what happens is that when a bullet strikes someone in the head, it displaces the contents of the head, being the blood, the bone, the brain matter. So you get something that's called blowback, which is that matter being expelled from the entry wound. So there was also, and I observed again, the photos of the vehicle as well as the video of the vehicle, and I was looking to see if there was any blood on the passenger seat, on the passenger side, in the passenger door, the floor, the roof, the dash. There was none. There was none on the top surface of the center console. All of the blood was in the driver's seat, the driver's floor, the roof of the driver's seat, the backrest, the pad or bottom where your legs and butt are, and also through the driver's headrest. So that tells me that when Mr. Anderson was shot, that he was facing straight ahead. Because Officer Mensah was perpendicular to the front of his body, and the bullets went into the side of Mr. Anderson's head, and because of the blood that Mr. Anderson, when he was shot, he was in the driver's seat. If Mr. Anderson had been lunging towards the passenger seat, that's where his body would have been. When they found his body, he would have been at least, if not in the passenger seat, at least leaning towards the passenger seat. But most interesting to me is that his hands are being described as being in his waist or in his lap. So there's no way that he could be shot while extending or leaning or lunging towards the passenger seat and then afterwards be upright in the driver's seat with his hands on his lap. Wisconsin Statute 175.47 sets forth minimum requirements which govern the investigation of officer-involved deaths. Under sub 1 sub C, an officer-involved death means the death of an individual that results directly from an action or omission of a law enforcement officer while the officer is on duty. Under sub 2, each law enforcement agency is required to have a written policy regarding the investigation of officer-involved deaths in their agency, and under sub 3 sub A, the statute requires an investigation conducted by at least 2 investigators, one of whom is the lead investigator, and neither of whom is employed by the agency of the officer under investigation. In order to satisfy the requirements of Section 175.47 sub 2, the Milwaukee Area Investigative Team was created in 2016. 21 law enforcement agencies contribute resources to the team and utilize it when there is a need to investigate an officer-involved death. The court is also aware of Wauwatosa Police Department Policy 17-11, Exhibit 5, regarding the investigation of law enforcement-involved fatalities effective August 4th of 2017. The court has also reviewed the position statement on Section 175.47, filed previously by counsel for former Chief Weber. This court is concerned only with whether there is probable cause that a crime has been committed by Officer Mensah based upon his fatal shooting of Jay Anderson Jr. on June 23rd of 2016. Consequently, the court is not concerned with assessing compliance with the statute or the agreements that resulted from it. The court is concerned with any actions or inactions that have compromised the objectivity of the investigation or the integrity of the evidence. In this case, the Milwaukee Police Department was designated as the lead investigative agency in the investigation of the death of Jay Anderson Jr. Detective Luke O'Day was the lead investigator for this investigation. Milwaukee Police Department Detective Nicholas Johnson was assigned to conduct the on-scene investigation at Madison Park. He was the first member of the Milwaukee Police Department to arrive at the scene, arriving at 4:05 a.m. Milwaukee Police Department Detective Troy Porter interviewed Wauwatosa Police Officer Ralph Salyers at the scene after being dispatched there at 3:59 a.m. Officer Salyers indicated that he searched the pockets of Mr. Anderson for identification before the Milwaukee Police Department arrived on the scene. He stated that he recovered a bag of suspected marijuana, a cell phone, and money from his left pocket. He then said he also recovered a state of Wisconsin identification card, but he could not recall what pocket he located it in. Detective Porter also interviewed Wauwatosa Police Officer Stephen Mills at Madison Park. He indicated that he had observed a gun on the front passenger seat while clearing the car. He removed it with gloves and put it in the trunk of his squad car in a plastic bag. Officer Salyers was present when Officer Mills observed the gun, but said he did not know where on the seat it had been located. Officer Mills also provided no additional information as to the location or positioning of the gun. No photos were taken of the gun before it was moved. Mr. Harmoning testified to concerns about the handling of the gun allegedly recovered from the passenger seat. When I see the inventory of the gun, there is nothing mentioned about bullets being in it. Now I found another report from the crime lab where things are going to be analyzed, and now there is a notation that there is 17 bullets in it. It says nothing about being unloaded from the gun. It says nothing about whether or not there was a bullet loaded in the chamber even. That is critical evidence that the Milwaukee Police Department didn't get to because Wauwatosa had already handled the gun, had already removed it from the car, had already cleared it. I don't know if that means they unloaded it or if they looked and saw that there were no bullets in it to begin with. Then they put it in a plastic bag and stick it in the trunk of a squad car until they handed it to Milwaukee. It is another critical piece of evidence that was compromised. Mr. Burns testified that the only thing the Wauwatosa Police Department should have done was to secure the scene, to make sure that it was not disturbed, to make sure that it stayed in the same condition that it was in at the time the crime occurred, and to administer any type of aid to Jay Johnson. He went on to state, there was no reason to move the gun. There was no reason to allow Officer Mensah to manipulate his vehicle. There was no reason for them to go to Madison Elementary to obtain video because video can be tampered with. There was no reason to do any type of canvass because you don't even want to create the possibility that there could be some improprieties and some bias, but you see it in this investigation. Ms. Holmes and Mr. Harmoning also testified that the scene should have been secured and undisturbed until the Milwaukee Police Department arrived. It should also be noted that although it is undisputed that Officer Mensah had his takedown lights on and his emergency lights off during his encounter with Mr. Anderson, by the time the Milwaukee Police Department arrived, the takedown lights were off and the emergency lights were now on. Chief Deputy District Attorney Kent Lovern set forth the relevant Wisconsin law concerning use of force and self-defense in Wisconsin in his December 5th, 2016 letter finding the conduct of Officer Mensah justified. Section 938, sub 1 of the Wisconsin statute states, a person is privileged to threaten or intentionally use force against another for the purpose of preventing or terminating what the person reasonably believes to be an unlawful interference with his or her person by such other person. The actor may intentionally use only such force or threat thereof as the actor reasonably believes is necessary to prevent or terminate the interference. The actor may not intentionally use force which is intended or likely to cause death or great bodily harm unless the actor reasonably believes that such force is necessary to prevent imminent death or great bodily harm to himself or herself. Under State of Wisconsin versus Head, a self-defense claim is subject to a two-part test containing both a subjective and an objective component. Number one, did the officer have an actual subjective belief that deadly force was necessary to prevent imminent death or great bodily harm to himself or others? Number two, was that belief objectively reasonable? William Harmoning testified regarding the leading United States Supreme Court decisions concerning use of force, Graham versus Connor and Tennessee versus Gardner. Mr. Harmoning testified that what those two cases tell us, in fact, they tell police officers, because it's embedded in their training, number one, if you are going to use deadly force, it has to be in response to an active and imminent threat of death or great bodily harm. Now, a threat is kind of a subjective thing sometimes. That is what Tennessee versus Garner told us. 4 years later, in the Graham case, they gave us a way to evaluate that threat to determine if it is reasonable. The standard is actually the reasonable officer standard. It is not necessarily the state of mind of the officer involved, although that is a piece of the evidence. It is the state of mind of a reasonable officer. The way we determine the intent and motivation of the reasonable officer is through an analysis of the totality of the evidence. He went on to testify that he did not believe that Officer Mensah was in reasonable fear for his safety, that the force he used against Mr. Anderson was objectively reasonable, and that there was no active and imminent threat at all in this case. Therefore, deadly force was not justified. Ricky Burns testified that he did not believe an objectively reasonable officer in Mensah's position would have used the amount of force that he used under the circumstance. He also testified that he did not believe that Officer Mensah was in imminent danger or risk of death or great bodily harm. He also does not believe the officer was acting in self-defense when he shot Mr. Anderson. James Trainum also testified that the amount of force used by Officer Mensah was excessive. Mr. Burns testified that he believes probable cause exists to charge Officer Mensah with homicide by the negligent handling of a dangerous weapon, in addition to second-degree recklessly endangering safety. Mr. Trainum testified that he believes probable cause exists to charge Officer Mensah with second-degree reckless homicide and homicide by negligent handling of a dangerous weapon. Ms. Holmes testified that she believes probable cause exists to charge Officer Mensah with second-degree reckless homicide and homicide by negligent handling of a dangerous weapon. She also testified that Officer Mensah created an unreasonable and substantial risk of death or great bodily harm to Mr. Anderson. The court in this case is tasked with determining whether or not there's probable cause to believe that Officer Joseph Mensah has committed a crime in the fatal shooting of Jay Anderson, Jr. Although the petitioner has requested, and witnesses have testified to, a variety of crimes where they believe probable cause exists, the court declines to review every possible charge, as that is not what the statute requires. The statute requires the court to determine whether or not probable cause exists for a crime. In the event that the court appoints a special prosecutor in this matter, that individual will have to decide which charge or charges, if any, they believe can be proven beyond a reasonable doubt, a far higher standard than probable cause. Homicide by negligent use of a dangerous weapon, as defined in Section 940.08, is committed by one who causes the death of another human being by the negligent operation or handling of a dangerous weapon. This crime has three elements which must be proven beyond a reasonable doubt. Number one, the individual operated or handled a dangerous weapon. Number two, the individual operated or handled a dangerous weapon in a manner constituting criminal negligence. And number three, the individual's operation or handling of a dangerous weapon in a manner constituting criminal negligence caused the death of another human being. Criminal negligence means the individual's operation or handling of a dangerous weapon created a risk of death or great bodily harm, and the risk of death or great bodily harm was unreasonable and substantial, and the individual should have been aware that his operation or handling of a dangerous weapon created the unreasonable and substantial risk of death or great bodily harm. Based upon the totality of the circumstances, the court does find probable cause that Officer Joseph Mensah operated a weapon in a manner constituting criminal negligence, and in so doing, caused the death of Jay Anderson, Jr. Therefore, the court finds probable cause that Officer Mensah committed the crime of homicide by negligent handling of a dangerous weapon. The basis for this finding rests with the testimony received over the course of these hearings. There is reason to believe, based upon the testimony, that Officer Mensah created an unreasonable and substantial risk of death, that he should have been aware that his handling and operation of his weapon created an unreasonable and substantial risk of death. This record is filled with testimony of alternative choices that Officer Mensah could have chosen to de-escalate the situation or recover the weapon without shooting Mr. Anderson, including waiting for backup, which was already en route. The conduct of Mr. Anderson was consistent with a person under the influence of intoxicants who had been asleep, who was trying but having difficulty complying with the orders of Officer Mensah. That unreasonable and substantial risk of death was further increased by Officer Mensah moving to a position where he could no longer see the gun that was the basis for his concern. If Mr. Anderson was fake sleeping, as Officer Mensah suspected, and intent on harming the officer, he would have likely taken possession of the weapon before the officer even approached his car. It is unlikely that he would have allegedly moved his hand towards a weapon 4 times without picking it up if his intent was to harm the officer. There is also probable cause to believe that Mr. Anderson never lunged for a weapon, as that claim is inconsistent with the physical evidence in this case. For all these reasons, the court finds probable cause for the above charge. The ability of the police to use deadly force when faced with life-threatening situations is a necessary and established privilege, but it is not a blank check. The court's review of the investigation in this case raises serious concerns regarding the adequacy of the current statutory framework for investigating officer-involved deaths. If the goal is to maximize objectivity and minimize bias, it will require a legislative alternative to having local law enforcement agencies investigate each other in officer-involved deaths. The record in this investigation is replete, both with things that were done that should not have been done, as well as other things that should have been done that were not done. Local law enforcement agencies often border each other, often assist each other in responding to crime, and occasionally find themselves defending each other from harm. It is unreasonable to ask them to turn around and investigate each other in matters as serious as these, and for them to suddenly set those relationships aside. It is similarly unreasonable to have local district attorneys reviewing the officers that they work with and depend on to prosecute crimes on a daily basis. The issue here is structural and is not based upon the personalities occupying positions at any given moment. If there is a serious desire to achieve maximum objectivity and independence in these investigations, the current statutory requirements are likely to continue to frustrate those goals. This case is going to be adjourned for 60 days for the court to appoint a special prosecutor. If that goal is achieved in advance of that time, the court will be in contact with the parties to set an earlier date. Thank you.
Thank you, Your Honor.
The clerk will set a date with you.